This is Danny Bobrow, President of AIM Dental Marketing, welcoming you to this installment of the Practice Perfection Web-Based Education Series. Today's presentation is titled, The Use of Legal Entities for Tax Reduction and Lawsuit Protection. Keep What You Earn. And, owing to a flight delay experienced by Gary Harker, tonight's presentation will be delivered by a most worthy replacement, Legally Mind's own president, Mr. Lindsey Thompson. Medical professionals have unfortunately become all too easy targets for many trial attorneys. Learning how to use legal entities is vital to protect everything they have worked so hard to achieve. Setting up C Corps, S Corps, and LLCs is only part of the answer to this rapidly growing issue. This course will deliver guidance on how to protect one of your most important assets, namely your license to practice dentistry and medicine. Lindsey Thompson is the current president of Legally Mind, where he has worked for the past 7 years. Lindsey has 12 years of experience working on projects for Boeing, Lockheed Martin, eBay, and Pacific Power. Work in the fields of manufacturing, marketing, environmental infrastructure, and entrepreneurship has given him a unique perspective on the importance of proper legal structuring for business, including dental and medical business. Lindsey's current roles include staffing, training, quality control, marketing, and education. As a professional and entrepreneur, Lindsey understands the necessity of asset protection, protecting the people closest to you, including your family, partners, and employees. As an attendee today, you will learn to protect all assets, whether business or personal, from any lawsuit, from any direction. To remain focused on improved patient care instead of malpractice defense. To understand your present legal structure to reduce your income tax, the proper use of trust, partnership, LLC, and other entities, and to apply a streamlined collection of effective protocols to help protect your license to practice. You are invited and encouraged to submit your questions at any time using the question button on the provided menu. If Lindsey cannot get to your question during the webcast, he has promised to do so shortly following his presentation. Attendance at today's event entitles you to apply to receive 1.5 hours of PACE-approved continuing education credit. Shortly following Lindsey's presentation, you will receive information on how to apply to receive your CE. To be eligible, you will need to successfully complete a brief quiz as well as note the following course number, which is THO 042023. Again, that's THO 042023. And now it is my distinct pleasure to welcome to the Practice Perfection stage, Mr. Lindsey Thompson. Hello, Lindsey.
Hi, Daniel. How are you?
Very well, thank you. We've been looking forward to this for quite a while.
All right, so let's get started. I'm Lindsey Thompson, as Daniel explained, and Gary couldn't make it today, so I'm your fill-in. I'm the president of Legally Mind. I've been with the company since 2016, and we've been speaking to associations just like this one and providing CE since about the early 2000s. In fact, our roots go all the way back to the origins of the FLP. We'll talk about that later. That stands for Family Limited Partnership, and not a lot of people have heard of that. And the LLC, you've heard of that one. A lot of you probably have your own LLC, S Corp, C Corp, something of that nature. And I'm going to talk to you today about how those entities work with an FLP to protect your assets and reduce your tax bill. So hopefully that's a topic that most of you find applicable for more than just CE credit, okay? All right, let's start off with a scenario. Let's say a patient walks into a doctor's office, sits down, takes a bottle of water out of a bag, pours some on the floor, lies down in it, and starts writhing in pain. You see where this is going, right? What happens next? The doctor gets served with a lawsuit. In this case, let's say it's $7,200. How did they come up with that number? Why $7,200? The cost of medical bills, pain and suffering, none of those things. They decided to actually sue for $7,200 because they called around to a few law offices to find out how much it would actually cost to fight a lawsuit like that, and that estimate came out to be $7,200. So now you're faced with a question. Would you rather pay $7,200 to start a lawsuit or to settle one? Hopefully that's a choice you'll never have to make, but we're going to talk to you about how to navigate that. This is why it's so important to protect your assets. Have you seen billboards like this? Dan got us $600,000. How much can he get you? What's your case worth? We all know that we have a problem in this country, and Americans tend to be very litigious. But how bad has it really gotten in recent times? The United States makes up 5% of the world's population. Yet, we now make up more than 90% of the world's lawsuits, so it's very disproportionate. Last year alone, there were over 100 million lawsuits. USA Today conducted a survey. They asked people, what's the best way to succeed in America today? Top answers. Things you can guess, right? People are going to say things like inherit money from your parents, win the lottery, or very popular is sue somebody, because the philosophy tends to be, you have more than I do and I need it more than you do. So the real question is, we all know we have a problem. Why don't we fix it? Well, our nation is literally run by attorneys. The attorneys write the laws, enforce the laws, and it's not in their best interest to fix this problem, okay? We're the only nation in the world that doesn't have a penalty for filing a bogus lawsuit. So you're almost encouraged to be, a litigious person. What can we do about this problem from our perspective as professionals? It all comes down to two things, cause and motivation. Every lawsuit is about those two things, cause and motivation. Cause is something we can't always control. There are some things that are just going to happen. But motivation, we can and must control. So the philosophy is, we're going to show you how to control the motivation and prevent people from wanting to sue you. A few years ago, one of our attorneys attended a conference, and there was a breakout session titled, How to Ensure a Seven-Figure Settlement When Suing a Medical Professional, believe it or not. And they thought this might be interesting and decided to attend. The attorney teaching the course proceeded to tell them about a recent case involving a patient who was leaving a doctor's office when the receptionist called out to let him know he forgot some paperwork. As he turned to go back inside, one of those big glass doors hit his foot, knocked him to the ground, and he hit his head on a table, damaged the part of the brain responsible for taste and smell, and decided to sue. He told his attorney he wanted $60,000 because that was his estimate of what it would take to cover the medical bill. But the attorney, as you would guess, said, hang on a second, you're suing a doctor? First, why don't we see what they're really worth? So they did a little research, and after some due diligence, they found an umbrella policy, check. A general liability policy, check. But what else could they get? Here's what's on the table. Bank accounts, a home, investment accounts, real estate. All of it was on the table. Nothing was protected, and it's what we would call easy money, right? He then went through 47 different focus groups to understand what type of jury he would actually need to win a case like this. And the best arguments after that focus group turned out to be things related to emotions and personal experiences. So he had to figure out how to present this information in a way that would win the most empathy from the jury. His selected jury, middle-aged, overweight males. They were the most empathetic, apparently, to the loss of taste and smell. I resemble that remark, so I kind of take exception to that, but that's okay. This was his closing argument. Close your eyes and think back to when you were 5 years old. It's Saturday morning. You wake up to the smell of fresh bacon, pancakes, fresh maple syrup. Imagine knowing you'll never smell that again, never taste that again. Those moments lost forever. The outcome, $5.2 million was awarded. Can you imagine how frustrating that would be? How helpless you would feel watching everything you have taken from you with the stroke of a gavel? Remember, he didn't do anything wrong, but what did he do? He left everything on the table. He left the motivation on the table. What do you think he would have paid to prevent himself from ever going through that lawsuit in the first place? Sometimes lawsuits are unavoidable, so what could he have done differently in this case? You can't stop someone from suing you, but you can take the motivation off the table. The worst way to own your own assets. This is a real simple one. Own them in your own name. If you want to do a terrible job, just do that. It's going to be real easy for you. This is important. In order for asset protection to be effective, it has to be done the right way, the right type of entity in the right state with the right verbiage. Otherwise, it doesn't work at all. It's as if you have nothing. What if we could take 98% of all of what we call safe assets and put them in a lawsuit-proof vault where only you hold the key? 98% of all your safe assets completely off limits. Motivation off the table. I'm going to show you how to do that. Strategy number 1, the family limited partnership. In an FLP, you have a general partner and limited partners. The general partner holds the key to the vault, so they have 100% control. Because of that, they assume 100% of the liability. The general partner could be you, it could be a spouse, whoever you want, but how much ownership do we want to give you, the general partner, if you hold all the liability? So we placed all your safe assets in one location, and now we can limit your liability by the percentage of ownership we give the general partner. So how much do you want them to own, and how much do you want to own? You want to own the smallest number possible, 2%. It's required that you own at least 2%. Otherwise, we would make it 1. 2% liability with 100% control. So what have we done? Well, if someone sues you and wins, 2% is the most they're going to get. And unless you're Bill Gates, 2% is not a lot, so we've reduced the motivation. See where this is going? So 98% of all of your assets are now protected. Who are the limited partners? Well, that could be you, could be a spouse, children. Limited partners have no control and therefore no liability. So we're going to place 98% of your safe assets under this ownership. Now, if you're married, you might actually consider setting up a management company where both you and your spouse can just be 50-50 partners. That way you share equal control, but the liability is still limited to 2%. So strategy number 1 is to create an FLP, or a family limited partnership, and place all your safe assets in it with a 2% general partner, protecting 98% of all of your safe assets from any liability at all. The Trial Attorneys Association didn't like this, so they fought it all the way to the Supreme Court. And there, the Supreme Court determined that limited partners cannot be sued, and ruled in favor of the FLP with a 9-0 vote. What assets motivate lawsuits? Guys, this is an easy one. You all have these. If someone's looking into you, what are they going to find? Well, let's start with safe assets. Safe assets are valuable things that wouldn't by themselves cause a lawsuit. Things like bank accounts, investment accounts, retirement accounts, artwork, jewelry, personal possessions and valuables in your home, all those types of things. None of these things are going to cause a lawsuit, but this is the motivation for every lawsuit. And there can be exceptions, right? You could have classic cars and maybe those cause a lawsuit, but for the most part, everything that's contained in that category would be on that list. These are the assets now that can cause lawsuits. These are things that by themselves can be responsible and be the cause. So that's why we call them high risk. What high risk assets do you have on the table? Firearms, your office, your home, again, cars, equipment, land, basically anything that could potentially provoke a lawsuit. Now, most of us actually have both of these, and safe assets and high risk assets are things that we just acquire throughout our lives. So how do we take them off the table without just giving them all away? Let's talk strategy number 2, using individual and unique entities like LLCs to protect each asset. It's important that you use the right type of entity. So like we talked about, that could be simply a partnership, an LLC, a sole proprietorship, an S Corp, or a C Corp. Too often, we improperly use the LLC. It's limited. So what does that mean, really? What are the limitations of liability in an LLC? Placing too many assets in an LLC makes you an easy target for a lawsuit. what happens if a patient decides to sue my practice? And I have my equipment, my home, and my practice in the same LLC. It's all going up in flames, right? You bundle it all together, they're going to see that as more value, and any attorney that takes a case like this is going to come after everything. By placing high-risk assets into individual LLCs, we mitigate the potential damage of any lawsuit. So we're going to separate our high-risk assets. That's the way that we set it up so that if someone sues your practice, your home is still protected. Now, if you want to be successful, do what successful people do. Who uses this strategy? Disney, pretty successful. They're worth almost $200 billion. Walmart, they're closing a bunch of stores for different reasons at the moment, but they're still worth about $400 billion. Virtually every major corporation in America is set up this way. Now, if I come see you in your law office or your medical practice, how many forms do I have to sign before you can consult with me or see me as a patient? At least 3 or 4, sometimes more. But I can be a 92-year-old with a heart condition and a back problem and buy a ticket, walk into Disneyland, get on any ride in the park without signing any waivers at all. How do they get away with that? Well, let's say I'm that same 92-year-old and I get on Thunder Mountain Railroad. If any of you have ever been to Disneyland and you've been on that ride, you'll know what I'm talking about. There's a part where it seems like you're going to hit your head on a big wooden beam. Gets me every time. So what if I get so scared that I have a heart attack? Well, Disney's attorneys are going to see that I got into cart number 4. Let's see who owns cart number 4. Well, turns out it's owned by Cart Number 4 LLC. So congratulations, your suit is with Cart Number 4 LLC. Guys, what does Cart Number 4 LLC own? That's right, Cart Number 4, just like you guessed. Walmart, same thing. Do you think there's more accidents in a Walmart store or in the parking lot? Probably the parking lot, right? You fall down in the Walmart parking lot, think you're going to sue, and hit the jackpot until you find out the only thing Walmart owns in the parking lot is asphalt. So the Walmart parking lot itself owns the asphalt, not the store. If Disney and Walmart are using this strategy, the question is, why can't you do the same thing? Why can't all of us use that same strategy? I'm going to let you sit on that and feel bad for a minute, and I don't want you to feel too bad, but maybe a little. We want to create more protection than a simple LLC provides. So ask yourself this question. Do you know any business owners who have been sued? And if they're business owners, they probably had at least one LLC. Most business owners do, or some type of entity. How did they wind up in a lawsuit? Well, the trial attorneys have created loopholes in our legal system that allow them to go around and or through your entity. First, they created a law that allows them to pierce your LLC. It states that if a company is owned by fewer than 100 people, it's considered closely held. Judges can choose to pierce the corporate veil of a closely held corporation and make your personal assets available in a lawsuit. So if you have an LLC owned by less than 100 people, it can be pierced. Okay, judges can choose to pierce the corporate veil of a closely held corporation and make your personal assets available. So that's the reason why we want to ensure that you're not susceptible to these types of actions from judges and from the legal system. There's also a corporate dissolution law. Judges can find any number of reasons to simply dissolve LLCs at will as if they never existed. And just like that, your personal assets are back on the table. First, you're going to need a holding company. A holding company acts as a management company for your LLC, but it's not just for organizational purposes. A properly structured holding company can protect you from the charging order if it's incorporated in the right state. Take your bank, for example. Your bank is local in most cases, and it may operate in your state, but where is it held? Probably Delaware. Okay? The reason for that is that a lot of banks are held by Delaware corporations. They have very strong asset protection laws, and it's favorable. So you can incorporate in any state you choose. We use an Alaska holding company, and I'm going to get to that in just a minute and kind of explain why. In the other 49 states, a judge can take any number of these measures to make your assets available in a lawsuit. So they can dissolve LLCs, they can seize assets, foreclose membership, or simply order distributions using the charging order. In Alaska, remember that Supreme Court ruling in 1974? They cannot dissolve LLCs, seize assets, foreclose memberships, or order distributions using the charging order. And it's unlikely to change because about a third of the state's tax revenue comes from entity and property renewals. It was 31% last time I checked. You can imagine the Trial Attorneys Association wasn't too happy with this. So they made sure every corporation had a pro rata distribution clause to give the judge the authority to force you to pay a distribution to someone who sues you and wins. Sounds fair, right? But it basically gives the judge control of your corporation. This is what happened to the doctor in the case I told you about earlier. Remember, he lost $5.2 million in a lawsuit? Well, general liability insurance paid out $1 million. Then the umbrella policy paid out $1 million, but that left $3.2 million. Then they liquidated all of his assets, and that generated another $1.8. But he still owed $2.4 million. So now what? The judge issued a charging order, took control of his practice, put him on a $45,000 a year salary, and forced him to pay every penny above that to the plaintiff until the $2.4 million had been satisfied. Guys, what would this do to your life, your family? Can you imagine how destructive that's going to be? How long would you be working to pay off a judgment like that? More importantly, how do you keep this from happening to you in the first place? Brings us to strategy number 4. Every entity we set up has a non-pro rata distribution clause. Okay, so this verbiage in your articles prohibits the judge from ordering a distribution from your company. You're the only one who can do that. We'll also review your existing entities and amend them to include this language. We've reviewed thousands of entities over the years, and almost all of them were set up using a template created by who other than the Trial Attorneys Association, believe it or not. So it's a real easy fix, but you have to know how to do it. It's not just as simple as add the word non with a hyphen right before it. So what if someone decides, I know the most I can get is 2%, and even if I win, I may never see any of that money, and they proceed with the lawsuit anyway? Well, as you could guess, even if there's no payment made to the plaintiff, who's still going to want their money on that judgment? You guys know these guys all too well. The IRS, right? So who owes the taxes? Let me give you an example. Let's say we'll call this person John. Let's say John decides to sue Dr. Wilson, and John wins. The judge says, Dr. Wilson, you owe John $1 million. Are you going to pay John if you don't have to? Probably not. Okay. Now, John, you owe the taxes on $1 million judgment that you'll never see. How do you feel about that if you're John? Pretty upset, right? You went to an attorney, you said, hey, is this a good lawsuit? They coached you through it, said, yeah, I think this is good. He's got a lot of assets. We're going to sue this doctor. You'd be pretty upset when you find out that you owe taxes on money you're never going to get, and you might even sue your attorney.
So let me understand this, Lindsay. Sorry to interrupt.
Go ahead.
You're saying that if there's a judgment and the plaintiff prevails, but he never receives $1 million, even though that's not a realized windfall for him or her, they need to pay the IRS on funds never received?
Yeah, and there's no guarantee the IRS will come after you, but from my experience with the IRS, they're going to look for any way they can. So they're going to attempt to collect from the person that won the lawsuit, regardless if they ever received the money or not.
That's surprising and disappointing,
yeah.
But maybe it shouldn't be
very
surprising.
Very aggressive. Yeah, I mean, is it really that surprising? It's kind of par for the course, but it's definitely disappointing, that's for sure. So that's why we want to let you know that suing our clients can actually create risk for the attorney. So all of you guys thinking about drawing up lawsuits, you may as well just put those ideas in the back of your head right now. Okay. Using these 4 strategies, we've created a nearly impossible situation for a trial attorney. We have a 12-year track record with over 12,000 clients, none of whom have ever been successfully sued. Lawsuits have come up, don't get me wrong, but they'll be dropped because if someone sues you, we're your first call. And the first thing we do is call the opposing counsel and explain how you're structured. For instance, one of our clients was notified of a lawsuit against the company he had formed with 3 partners. When he told their attorney, he wanted to put them on the phone with his asset protection team. The attorney asked who that was. We said, here's how he's structured, and here's kind of the obstacles you're up against. And later, he was notified that he was removed from the suit. So they simply went after the partners. Not great for the partners, but I mean, if the partners would have had their assets protected, they would have moved on to a different set of partners altogether. But we have another client, for example, who's personally never been sued as a doctor, but his wife happens to own a small business and a rental property, and as luck would have it, she's actually been sued 3 times, and all 3 were dropped because of how their assets were structured. We see this happen all the time, and we've been doing this a very long time. So remember, our goal is not to win lawsuits, and we definitely can't stop people from trying to sue you. So the question really becomes, what are we even good for? What are we doing here, right? Well, we can make you really unattractive. That's the goal. So we want you to appear homeless and just not real appealing for a lawsuit. So what's next? Now that all of our assets are protected, what do? Well, technically, they're protected only during our lifetime. So what happens when we die? We want to make sure everything we work so hard for goes where we want it to. You've all heard of a living trust. What type of a trust is actually best for you? The vast majority elect to have a revocable trust because it can be modified. So if your life changes, which all of ours do, and they change year to year, that's the one you want to go with. That being said, you might have an asset that you want to put in an irrevocable trust. And that's something in a very special circumstance that it can't be changed by anyone, including you. So you have to be very careful about whether that's the type of entity you want. But in some cases, those do make sense. And we suggest that you talk to us or a professional about that before setting it up the wrong way. Now, obviously, you don't have to chime in all at once here, but think to yourselves, how many of you have actually done estate planning? And when I say estate planning, how many of you just think of a will? A lot of you probably, right? Maybe most of you. So a living trust has tax benefits, but it also protects your assets after you're gone, just like a will. The difference is that living trusts are not disputable, so they do not go into probate. I'll say that again. Living trust does not go into probate. A will send you right to probate when you die, which means anybody who thinks, hey, I should be able to dispute this, you might have one of your children. Everybody knows a group of siblings that don't talk to each other anymore because of some type of estate battle or something of that nature, right? So if you have that set up in a living trust, probate is completely skipped right over, and your entire estate is going to go exactly where you want it to. Having a living trust is the only way to avoid probate. A living trust ensures that your estate goes where you want it to and not to the attorney. Let's talk about some tax advantages. It's good not to be sued. It's good to keep all your money, but it's not good to pay a good chunk of that to the IRS every year. So we can actually help you put $10,000 to $20,000 back into your pocket at tax time. How many of you think you're overpaying on your taxes? I hope all of you. I know I do. Do you think the IRS is going to say anything about that? No. Here's a quote directly from the IRS handbook. It's right on the front. It is the responsibility of every American citizen to ensure they do not overpay their taxes. So whose fault is it that you're overpaying? That's right, it's yours. And unless you keep up with the changes, it's going to get worse every year. And that's because there are changes in tax law every year. So you have to make adjustments according to what changes happened that calendar year. We leverage more than 20 different tax strategies for our clients. And the most important part about these various strategies is that each one is actually vetted thoroughly by our tax attorneys and the IRS to ensure that they're being used correctly. We don't have time in this webinar to go over all of them, but there are a few examples that I can give you. IRS Code Section 280AG is a good example. This allows your business to rent your home for board meetings, trainings, corporate events. Some of you may know this as the Augusta rule. Now, Augusta is where the Masters is held every year, biggest golf tournament in the world. Most of you have heard of that. Anyway, a few years ago, a few politicians from the area got together and passed legislation that would give them a huge deduction for renting their home out during the tournament. Now, the rental income is received tax-free, and it's a write-off. Remember, the politicians who make the laws have to apply them equally to everyone. As a result, you can take advantage of the same deductions they use if you do it correctly. Another common strategy is income shifting. So you can write off school expenses, even day-to-day expenses for your minor children. The best part is you don't have to know how to do any of this, okay, guys? We'll work with your CPA to make sure you're actually taking all the deductions you're entitled to. So whoever you're working with to properly protect your assets can coach you through this. You don't have to yourself take the time to become an expert in the area. If your CPA didn't recommend that you take the licensed professional deduction in 2022, ask yourself if that sounds familiar, and if not, you likely overpaid your taxes and you may want to give them a call back. So this is a tax deduction given for research and development. It's called the Professional R&D Tax Credit. As a Legally Mind client, we actually set up a free consultation with a tax expert who will go over those different things with you and talk to you about how much you can save. There are a lot of different attorneys out there, asset protection attorneys, that can do the same thing for you. Now, different from expenses, credits are actually a dollar-for-dollar benefit. So R&D tax credits refer to the time and the money invested in training and implementation of products and processes. So if you already have a CPA, like I'm saying, that you're happy with, we'll work with them. An asset protection attorney locally that you hired could work with them to make sure they're all aware of any tax breaks that specifically benefit healthcare professionals. We've been protecting medical professionals for over 40 years. So for the last 12 years, we've implemented a unique strategy for our clients. And since that time, we've worked with over 12,000 medical professionals from all over the nation. And do you know how many of our clients have been successfully sued using this strategy? 0. I'm not talking about getting them settled. I'm talking about getting them dropped. So if you've ever been through a lawsuit, you know how devastating they can be, even if you win. We've saved thousands of medical professionals and business owners from the emotional and financial struggle of going through a lawsuit. Tens of thousands of dollars in the process with their taxes as well. So this is not a system where you can simply take a box of instructional DVDs and, put them on a shelf next to your P90X workout videos. You need a professional to do the work on your behalf, unless you want to become the professional yourself, to make sure that it gets done the right way. That way you can focus on your patients, your family, anything but really taxes and lawsuits. We also want to talk a little bit about license protection, which is an important factor that not a lot of people think about. HIPAA, OSHA, and Medicare automated compliance systems are things that you need to keep up on, and there are audits twice a year. We can help you track that. We know how important this is for your license, especially if you're running your own practice. Your medical license is the most valuable thing you have. We also show you with Shield, which is going to protect you from the National Practitioners Database, or the NPDB, and state boards, if you happen to be listed in a malpractice suit. So these are some additional things that you need to take into account when setting up asset protection. Setting everything up properly can be very expensive. Okay, I'm just giving you a ballpark of what it's going to cost you to do this yourself, or to go locally and have a professional in your state do that. You need an asset protection attorney, you need an estate planning attorney, and you need a good CPA. Now, for those of you that have ever built a house, you know how valuable a good general contractor is. And for those of you who've built a house and tried to do it all yourself, you know how tough it can be to coordinate a plumber, an electrician, a carpenter. All those different factors can be a logistical nightmare. So we set everything up kind of in a holistic fashion so that everything works together. Okay, so what we want to do is take a quick minute to go over kind of what we've talked about. And Daniel, if you have any questions, now would be a good time to cover some of those things.
We do indeed. I just looked at the time. I'm amazed at how much you covered in such a short period of time. It was just info-packed presentation, and I want to thank you for doing it in such a time-efficient manner. We do have a number of questions, and that leaves us time to get to several. The first of which is, what is the most important thing to control to avoid a lawsuit?
The most important thing you need, you're asking me?
Yes, sir.
All right. The most important thing you need to control is the motivation, meaning you've got to make sure that it's just simply not appealing.
Yep. Okay. And you went through that. I think this question was asked early in the presentation, but yeah, sure. If you want to elaborate a bit, please.
Yeah, no, that's fine. If you want to successfully control the motivation, really all you're doing, and that's why I alluded to appearing to be homeless or making you unattractive, right? You don't want to have all your assets set up in a way that an attorney who does an analysis and does some due diligence is going to see you as an easy target. They're going to do just a cost analysis on the time they're going to spend fighting this lawsuit and the amount that they potentially stand to gain, or you as their client stand to gain. So it's not hiding assets, and a lot of people view it that way. It's simply a matter of successfully structuring it in a legal way that, according to the government, the IRS, everybody is completely legitimate, but only the people who really create the laws and know them inside and out are doing it regularly. The rest of us have to learn the hard way, or in this case, talk to people who've been doing this for years who can give you some, additional information on how to properly set that up. But really, it's just taking the motivation off the table.
Mm-hmm. It's a related question. I had no idea one could identify a professional's assets so easily. How is this done? I think you just mentioned it's the attorneys we have to thank for that.
Yeah, they're good at this. They do background searches all day, and you'll see them in a couple hours come up with a bunch of different entities and assets through their various channels that you own that are in your name. And that's why the worst way to own assets is in your own name, because it makes them the easiest to not find. I mean, you can find any of these things, but I would say it makes it the most convenient to sue you. Let's put it that way.
Mm-hmm. Well, it's been said you can't eliminate crime, but you can redirect it.
Yeah, exactly.
It's just
you don't have to outrun the bear. You just got to outrun your buddy.
That's right. Exactly. All right. Next question is, what can you do to protect against the charging order?
Great question. So the charging order is something that they came up with, the Trial Attorneys Association, to simply circumvent proper asset protection, in all honesty. Now, if you're set up with non-pro rata distribution clauses, and that's the kind of the key word here, the boilerplate software the Trial Attorneys Association creates and pumps out there for everybody to use. So you go to a local attorney, say, hey, set up an LLC for me. They set it up. They create the articles. We review those. And in every case that I'm aware of, it's set up with a pro rata distribution clause because they all use the same template, essentially. Mm-hmm. We actually go in, and asset protection professionals know how to do this. We'll go in and restructure everything with different verbiage so that it has a non-pro rata distribution clause. And it simply says you can lose a judgment. The judge can say you lost the case, hit their gavel, and you owe $1 million. But if you're properly structured with a non-pro rata distribution clause, that judgment sits there until you choose to pay it, because you're the only one that can actually order the funds out. Now, I have to give you some background on this, because does anyone want a looming judgment of $1 million over their heads? Probably not. It's not real appealing. But think about the effect that has if you're suing someone, just to know there's a chance that they're just going to let this money sit there, and people will try to collect from them, and it might ruin their life. But if they're stubborn enough, they can just hold out, and I'll never get my money. Are you likely to go forward with a lawsuit knowing that after all the pain and suffering and the legal fees, if you win $1 million, not only are you never going to get the money potentially, but you'll also owe taxes on that money? So again, the philosophy with asset protection is not be sneaky. It's create the strongest deterrent possible so that somebody would be an idiot to try to sue you.
And if I understand correctly, the sequence of events is that you create a non-pro rata distribution so that when the attorney being retained by the plaintiff does their due diligence, they will discover that that exists and then will advise their client that they might win, but they're not going to collect. Is that correct?
Yep, you got it precisely. It's basically, hey, I just got to give you, a good attorney will do that. They'll say, I've got to, in good conscience, give you a warning here that you might go through a lot of stuff and not have a good outcome.
Gotcha. Next question is there really no penalty for frivolous lawsuits?
There's a built-in penalty if you think about the financial repercussions, but there's no actual tangible penalty from the legal system.
There's no law. Okay.
So anyone can sue anyone anytime. And the only risk really is a waste of time, money, and if that person you sued wants to sue you back. But there's no legal ramification for filing a lawsuit that seems to be founded on shaky ground.
So when you hear the term bandied about frivolous lawsuit, that's not a legal term. That just means a lawsuit that really has no merit, but doesn't mean It won't be.
Yep,
it may not be worthwhile.
That's just as simple as it's a frivolous lawsuit. It's kind of a ridiculous lawsuit is essentially what that is.
Okay. Does a trust obviate the need for an FLP?
No, depending on what your purposes are. If your purpose is asset protection, you need an FLP anyway, so that's kind of a moot point. But if you have a trust, the trust will still prevent your estate from going into probate. If you don't have an FLP, the trust will still do its job.
Mm-hmm.
It's just not going to help you while you're alive.
Okay. Does a trust serve to hide one's assets?
Interestingly enough, no. But when you set everything up in a trust, since you skip probate completely and you don't go through probate court, the amount of one looking into one's assets takes a dramatic dip. And what I mean is, when something goes into probate court, it becomes a matter of public record. And what that means is anyone who from 30 years ago feels like you owe them money can put their name in the hat and say, hey, I would like to be eligible to take some of this money from this person's estate. Or in the example that I was trying to give earlier, excuse me, let's say you have a couple children and they fight over it. Now it's tied up in that lawsuit as well as the other person trying to collect money from you. It could be years. And you hear these stories sometimes about people who have millions and millions of dollars in their estate and they just have a will. And more than half of it gets parried away by attorneys over the course of several years. And by then, you've got people you wanted to give the money to that won't even get it. And it can be 5 years down the line before they even get that half.
I see. I think you probably answered this one sufficiently, but the question was, is there a difference between a will and a trust? Is one better than the other? I think we're all clear that a trust is preferable.
Yeah.
But you can have a will within a trust, correct?
A will is essentially within a trust. This is easy. The only difference between a will and a trust is a will is simply a set of instructions that you wish to be carried out. And that's still contained within a trust. It accomplishes the same thing. The difference is, again, that a will is just that and nothing more. Whereas a trust is a predetermined course of action that the courts are not going to have any say in. They simply have to follow the will in the trust, if there's a trust. But if there's just a will, then it goes into probate.
Got it. All right. Can you explain more on how the judge can pierce the corporate veil?
This is an interesting one because it's actually set up so that they can simply make a value judgment. They can say, based on what this person's trying to do, I think they're trying to hide their assets. I don't like that. And I've seen this in court a million times. It's shocking how much a judge can do just based on making a judgment right then and there on the spot. They'll say things like, I'm just simply, it's all situational. I'm just simply not going to honor this entity because I think, and that's the verbiage they'll use, this entity was actually set up for the purpose of asset protection only, and I don't like that, so I'm going to go ahead and pierce this corporate veil. Now, the problem is in those situations, you can count on your corporate veil being pierced. It's going to happen. The issue is if you have a non-pro rata distribution clause, that's going to be something that, again, the opposing counsel is going to be aware of. And if they're responsible, they will have made their client aware of.
Gotcha. All right, Lindsay, in the time remaining before concluding remarks, why don't you be good enough to share the offer that you'd like to extend to our attendees?
Yeah, that'd be great. I was getting ahead of myself. That's why I hit back on that slide button. I'm sorry I don't do a lot of these webinars. Gary was the one that was planning to do this. And
well, you could have fooled me, Lindsay.
Show me how to do this part of it. So here's the way this actually works. There's an $8,400 total cost for everybody that's on this webinar, and that's a $6,000 cost for unlimited entity creation. Okay, and that's now and in the future. So let's say you acquire a new asset and you just need an entity for it. You give us a call and we set it up for you, and there's no additional cost for that. The additional $2,400 covers the first year of our Premium Plus service. So that includes a personalized asset protection structure, your tax strategy, a registered agent, and unlimited access to our expert staff and our attorneys here. So in essence, you have an estate planning attorney, a tax attorney, and an asset protection attorney all on retainer. Your license, compliance, and protection is also all included in that. So that's kind of the summary of the things that are provided. And the HIPAA, OSHA, Medicare compliance is in there too. Malpractice risk mitigation with the Shield license protection also. To make these things easier, we actually offer a tax savings guarantee because sometimes it can be tough to make a decision on something like that. And we know it's a lot of money, but we're going to guarantee you get all $8,400 back in new tax savings. So what that means is after your first full year, you file your taxes. Let's say we only save you $5,000 and we can demonstrate that that's the actual savings. Then you're going to get a check from us for $3,400. Now, we don't offer that guarantee because we plan on writing a lot of checks. As you can imagine, we'd be out of business. We've got thousands of clients. We've written a handful of those checks ever. Sometimes there's a resident that is smart enough to say, hey, you know what? I'm not going to save much in taxes. I might be able to get a discount on this program. And then when I start making money, I will have gotten it for cheaper than other people. And they're not wrong. So when you sign up today, you actually pay $8,400. And if you don't save more than that, when you file your taxes, you get a check for the difference. And that $8,400 incidentally, go ahead.
Well, no, you go ahead. I can remember my question after you're done.
I was just going to say, you need to remember that that's a one-time fee. That $8,400, the $6,000 of that is paid upfront one time, and then $2,400 is the cost for the Premium Plus service that takes care of the maintenance every year, and that's going to be registered agent fees for the locations of your corporations. We have a registered agent in Alaska where we're going to set up a holding company, et cetera. So there are a lot of different services that you'll keep us on board for afterwards. You do have the option to cancel that other feature. In other words, after your first year, if you decided, hey, I'm pretty much set up or I'm retiring and I like where I am right now and I'm not too worried about an annual tax plan or keeping up on the laws or anything like that, you can simply cancel that and all of the asset protection structures that we set up for you remain in place, as well as the unlimited entity creation. So if you know what type of entity you need and you don't need consultative services from us, then we'll still do that for you even if you don't have that Premium Plus service. But most of our clients see the tremendous value of that annual Premium Plus service that ends up being $200 a month, and they end up keeping it for a very long time.
And didn't you also say that you talked about the employee retention credit? You're also set up to help the doctors apply for and receive that from the IRS, I believe. Is that included in this?
Yeah, so that's not something we do, but we are happy to provide you with, you imagine the clients that we have a lot of relationships with third-party companies that do a great job. And so we can definitely point you in the direction of companies that will take care of things like the ERC.
Excellent. All right. Well, is there anything else you'd like to share before we move on to concluding remarks?
All I have here is just a simple testimonial from the editor-in-chief of the American Journal of Orthopedics. And he's basically just saying, as professionals, we spend so much time taking care of ourselves. We need to worry about, taking care of others, that we need to start worrying about also taking care of ourselves. And that's very true. This is a situation where in order for you to do what you do and have peace of mind, and whether you're in the medical community or business or legal or any of those things, if you're focused on what you're good at, and then you let the people that are good at what they do, like the general contractor in the house, just focus on what they do, the results are typically far better. So that's what we recommend, regardless of the fact that we think we can do it more effectively and cost effectively too than anybody else. It's in essence a way to avoid you having to take a bunch of time out of what you do best to learn a lot of things that you're really only going to need to know in order to set it up properly once.
Well, and I know who's in attendance practice an ounce of prevention for their patients. And, you can believe in the goodness of mankind, and I do, and I'm sure our attendees do, but it only takes one unfortunate incident to upset a year's work. So I think this is money well invested, and I hope our attendees will take advantage of that. This is how we can get a hold of you, correct?
Yeah, so this is just my cell phone number, so it'll get you directly to me, and that's 801-473-1645. The event price is $8,400, and that's a special pricing. Normally, the pricing is about $13,800, and we so $13,795 to be technical. But we can help you do all these things, and it's pretty painless. I just want to add that. Don't be intimidated by all the information. In essence, you have to be available to answer questions and provide us with information as we request it from you, and we do all the legwork for you. And then you simply have a liaison here where you contact us and say, hey, I need an appointment, I need an annual review, or I've got a question, or I want to talk to a tax attorney, and then we set up an appointment, and there's no charges. We're not taking minutes or charging by the minute or anything like that, so it's all set up based on what your expectations are going in.
Excellent. Well, again, Lindsay, I want to thank you very much, especially for pinch hitting for Gary. You did a great job. I appreciate it. And now it's just left to me to let everybody know that in a few days, you will receive an email detailing how to apply to receive your 1 1/2 hours of continuing education credit. Now I want to invite you to mark your calendars for Thursday, May 25th, when my very special guest will be Dr. Kim Cooch, who will be returning to the Practice Perfection stage with his presentation titled Wellness Coaching for Dental Caries, Up Your Prevention and Treatment Game. Caries risk management is considered best practice in the prevention and treatment of dental caries disease, although early attempts in clinical practice have been overly complicated. Implementing this concept into daily practice affects all management systems in the office. More importantly, it requires new skills to help coach the patient along their journey to optimal health. This approach has been variously called motivational interviewing, patient-centered dentistry, and wellness coaching. Regardless of the name, this lecture will present this philosophy and verbal coaching skills to allow you to seamlessly integrate it into your practice. Kim's presentation will enable you to identify the commonly known risk factors and treatment strategies for dental caries, discuss the strategic decisions necessary to successfully implement caries risk assessment into daily practice, and utilize new coaching skills, verbal coaching skills, to help your patients achieve health. It all happens on Thursday, May 25th. So be sure to save the date and watch your inbox to register. Until then, this is Danny Bobrow thanking you for your commitment to practice perfection. And once again, thank you very much, Lindsay Thompson. Goodbye, everybody.
Thank you.